Well, good morning, everyone. We are at the end of 2022. This is our last daily Zoom for the year of 2022. We'll resume, of course, next week, Mondays through Fridays. This is where we get together with our distribution partners, whether you be an affiliate or a white label partner, talk about strategies, tips, techniques, and it's one of our primary ways of supporting each of you. We're very blessed and fortunate to see our distribution partner team grow. You could almost describe it as an explosion, dramatic increase in both white label partners and affiliates. And thank you for each of you that have come aboard. With that being said, today's topic is a serious one. So if you're an affiliate, this really isn't so relevant to you. You're welcome to be part of the training regardless. But if you're a white label partner, this is a big deal, because if you're a white label partner, what that means is that clients are signing contracts with you and making certain promises. Typically, it's going to be the access to capital template that we provided you in the white label partner Dropbox. So they're contracting with you, making certain promises to you, and of course, you have certain promises to them. What do we do when a client doesn't do what they promised to do? And so we're going to talk a little bit about that. And again, I'm not an attorney. I'm only a paralegal, can't give legal advice, but we can talk about topics, just can't give you specific individual advice, of course. So rather it be, regardless of the type of contractual default, so we want to look at this as it is. There's a contract, whether it be between you and the client or even us and you as a white label partner. There are contracts. So if someone breaches the contract, the first thing that would be done responsibly is to give the other party notice, to let them know, hey, there's a problem here. So if you are a white label partner and you have a client that maybe doesn't pay their refundable deposit, or they get funding and they don't pay their performance fee, or they're just not actively participating, it doesn't matter the reason for the breach. Your first responsibility, in my opinion, is to issue notice. Let them know that they're not doing what they should be doing. So it puts them on alert, as they would say. So you're not being mean. You're saying, hey, you're not doing what you promised to do. Because if you don't do that, they're less likely to resolve it. And maybe they're not aware that they're not doing what they should be doing. Same thing we do with our white label partners. We have white label partners that sign up, and sometimes they don't do what they promised to do. So we send them notice. So it's not mean, it's not ugly. It's just saying, hey, from our perspective, you're not doing what you should be doing. Let's correct it. So that would be the initial step that anyone would take when there's a contractual breach normally. Now let's go to the next step. So let's say that they ignore the notice. In other words, they don't seek to cure the breach. They don't seek to resolve it. So that's where it gets more creative of what's the next step. We've worked with a team of attorneys and advisors, and so this is what we do specifically. So I'm going to show you, not just talk about it, but show you specifically what we do, and you may want to do something similar. If you want us to handle the litigation for your breach contracts, in many circumstances, we can do that. And so you would just need to let us know. And so what we're going through here isn't saying you should go do this. It is making reference to what we do, and as we could also assist you in doing in some circumstances. So this is a real petition. It was filed yesterday. So it's real. And this is a white label partner. The white label partner signed up, and the white label partner breached the agreement. We gave notice. She didn't resolve it. So I've redacted her personal and sensitive information, which you should do. And we've learned painfully there's certain ways you have to redact and other ways you don't do it. So, of course, we understand that now. So we're going to redact properly. So we won't compromise this white label partner's personal information, of course. So this is literally the petition that we filed yesterday. So this is a common second step. You give notice when there's a breach, In other words, you as a white label partner might send a notice to your client. You might even invoice them via QuickBooks or what have you. But when they're not resolving that, this is a common next step. So let's look at this. Now, we understand the court system pretty well. And what I think any judge would tell you or legal advisor is you should do everything that you can to avoid suing people. You should try to resolve it. And there's two really instrumental strategies that the courts really like in most cases to see that you've tried before you file a lawsuit against someone that has breached contract against you. They like to see if you've made a settlement offer. In other words, you've shown some flexibility to try to resolve it without going to court, because going to court is expensive and time consuming. And there's court fees and such. And so in breach of contracts, you're almost always going to win if you're the plaintiff, if it's a clear breach of contract. The defendant, the person that's being sued, would have to have a good defense. And the way our agreements are written, that's next to impossible. So when you offer a settlement to the person that you are suing, it's showing the courts that you attempted to resolve it without going through the court system. Again, court system likes that. Doesn't require a settlement because maybe the other party won't agree. And then also alternative dispute resolution, ADR. And so this is where maybe you offer to work with a mediator or arbitrator prior to filing suit to, again, try to save the court's time. Because you take some of you, like Mr. Barchi, who's on the line, and Mr. Barchi, I don't remember offhand, but you've enrolled a large number of clients in 2022. There's some of them that have breached contracts with you. If you took all of those at once to the court system, it could kind of flood the court system, right? They wouldn't really, I mean, they'll do it because they're professionals and it's their responsibility. But if you can demonstrate that you've done what you can do to keep it out of the court system, that shows better. So this is our effort at trying to avoid going directly to suit when people breach contracts. And so with our new investors, this is what we do for white label partners that breach. This is what we do to debt buyers that have bought collateral support program, as well as direct clients. You may wish to replicate it in full or part, or we could assist you with this in some cases. But let's go through how this is structured. And frankly, some of you received this yesterday, unfortunately. So it's not ugly, it's not a threat. It is allowed by the Rule 202 of the Texas Rules of Civil Procedure. Now, we're in Texas, so we're following, of course, the Texas Rules of Civil Procedure. Everyone that we contract with has agreed to jurisdiction in Texas. So this works for us. If you're elsewhere and your contract's written differently, then I realize that this may vary a bit based upon the rules of civil procedure in your state. For those of you that have gone to law school, which is a good number of you, you know that there are federal rules of civil procedure, and then there's also state specific. All right, so how this is, and this is again the real petition that was filed yesterday. I don't know if they've assigned a cause number or not. I personally hand delivered it over, saw the judge yesterday, and I don't know if there's a cause number, but we don't put the cause number on it. The court has to put the cause number on it. So if you see that as blank, it's like, oh, this is fake. Well, no, it's the real. It's literally what was filed with the court yesterday, but the court assigns this. You and I don't, of course. And then they'll give you one back that is finished with the cause number on it. That's what you get back from the court. All right, so to the honorable judge of this court, business paralegal. Now, if you're a white label partner and you're the petitioner, it would have obviously your information. Again, not an attorney, not giving you legal advice, just describing how Rule 202 works and give you an example, which is a real example for whatever that means. Files this verified petition to take deposition before suit. So essentially, this is not filing of a lawsuit. We don't want to file a lawsuit against Corlance, but we're gathering information to determine if we will. We know there's been a breach. There's no question, because what the court doesn't like is what's called fishing, where you're just trying to get information to decide if you have a case or not. So we would never use Rule 202 to go fishing. We know that there's a breach. Now we're trying to determine, should we file suit and the magnitude of the suit. So let's go back to you as an example. So let's say you're a white label partner. You have a client that signed up and they stopped participating. Well, they might have used that information that you and I collectively have helped put them together, the financial literacy, the loan package, and they might have gone out on their own. And I'll just exaggerate for a moment. They might have gone out on their own and got $1 million loan, $1 million SBA loan. But of course, they may not want to tell you that because they would owe you the performance fee. Because remember, the way that the client agreement is written is any funding they get while they're under contract is applicable to the performance fee. And so you'll see that sometimes people will sign up, they'll use the information, the knowledge, the assistance, and then they'll go off the radar because they don't want to pay you, in that case, $100,000 performance fee. So in some cases, we need to gather more data to determine, should we file suit and how big should this suit be? And we've got a client in Georgia. We're getting ready to submit this on next week. We won't get it done today because the courts close early on Friday because of the holiday, here at least. But this client got an $800,000 PPP loan and has not paid. Well, they owe us $80,000. So with that being said, here what we're asking to do is to get information from the respondent. Now, normally in legal terms, you'd say this is the defendant, but there's not been a suit filed. So what we're trying to do is determine, should we file a suit and how big of a suit should it be? It's like we have white label partners. We have some white label partners that have taken our model and gone outside of our relationship and used elements of it. Well, they owe us for every client that they work with. And so we have to essentially subpoena information from them to be able to determine the magnitude of what's owed. Same with you as a white label partner. You really need to be looking at the records of these clients that have breached to determine how big is the suit that you have against them. And do you want to file suit or not? So we state, under Rule 202.1 of the Texas Rules of Civil Procedure, a person may, through a verified petition, which this is, ask the court, which we're doing, for an order authorizing the taking of deposition on oral examination or written questions for either of two reasons. And so this is just language in terms of how the rule is written. What we're doing is to investigate a potential claim or suit. For us, we list where we're at. This is our physical address. I'm sitting in it right now. It's a commercial address. If you're the one that is filling this out and you're the petitioner, of course, obviously you'd use your information, not ours. We clarify anticipation of suit. Petitioner seeks to perpetuate or obtain the deposition testimony of Corlins EBA. And again, for those of you online, this is a real white label partner that has breached. This was a real filing as of yesterday afternoon. I was at the courthouse for about an hour dealing with this. For use in an anticipated suit in which the petitioner may be a party. This petition is filed in Wood County, Texas, where Business Paralegal is located and services are performed. And all of our agreements have Wood County, Texas as jurisdiction. So again, as a white label partner, when you're taking that template and changing it, most likely you are going to change it to be your location, not ours. If you don't have this, again, not giving legal advice, just talking in general, if you don't have this type of language, what could happen is the person that you're in conflict with, if you understand what I mean, may come back and say, oh, no, you can't do this. And for instance, Corlins could come back if we didn't have this language and say, oh, I don't agree to this being in Wood County, Texas. This needs to be where she's based, which I think is Maryland. But she has waived that and agreed to Wood County, Texas. So again, agreements are important. And the template that we provide you as a white label partner in your white label partner Dropbox has your ability to edit it for your area. So then what's interesting with Rule 202, you don't have to state your whole claim, but just making some reference. And so in this case, we're making reference that it's to the white label partnership license agreement. We have some people that are both clients and white label partners, and you might have clients that you have multiple relationships with. So again, you don't have to provide a full description of the breach, but you need to make a reference to what this is about. And so in this case, this is a breach of the white label partnership license agreement by Corlins. Then then you state the person's information as well as the business, because you're going to typically go after, if someone breaches on you, you're going to typically go after them as an individual, and you're typically going to go after them as a business as well. This petition, and if you have any questions as we go through this, let me know. Some of you are joining late, so you probably don't have the context of what we're discussing, but if you have specific questions, just put it in Q&A. This petition is filed in Wood County, Texas, where the venue of the anticipated suit may lie. This court has subject matter jurisdiction over the anticipated suit. This court also has personal jurisdiction over Corlins eButt. Specifically, respondent agreed to Wood County, Texas as a jurisdiction stated in the executed agreement. Furthermore, the venue is proper because it's a county in which a substantial part of the events or omissions giving rise to this action occurred. Pursuant to Rule 202-4A1 of the Texas Rules of Civil Procedure, the requested deposition may prevent a failure or delay of justice in an anticipated suit. On information and belief, respondent has material information related to this potential claim. So this is exactly what I was saying a moment ago. If you're a white label partner and you have a client that is not participating, you need to find out if they've received funding, because if they've received funding, even from an outside source, they owe you the performance fee. But they've got the information and you don't, right? So you need to find it. From our perspective as white label partners, if we have a white label partner that breaches, we need to look at their financial records to see if they've been doing anything that's in conflict with our agreement, because what they may owe us may not just be the license fee, it could be a whole lot more, including identity of material witnesses, location of pertinent documents, and so forth. So what you can see here is this pre-suit discovery is meant to gather relevant data to figure out, do you have a suit and how big can it be? Because often the deeper you dig, the more you realize that the other person owes you, that you just wouldn't have known if you didn't have access to their financial records. All right, so skip through a little bit. We always want to identify specific case study. And so this is maybe the most important paragraph in this whole document. It is clearly and unequivocally established by controlling law that a petition under Texas Rules of Civil Procedure 202 is an investigatory tool for potential claims and is not subject to removal. So technically, the court can't say no to this. Now, maybe that's a bit of an exaggeration, but in general, the court almost always has to agree to this petition. And so there's case study that has established that. For any of you that have gone to law school or even just paralegal program like I've gone through at Rice University, what I learned that I didn't know before I went to that course of study is that courts must follow precedent. And so here we're establishing precedent. So we're just clarifying to the court that this can't be removed. In other words, the court legally can't not allow this petition to go through, and in fact, it'd be sanctionable. So then we request to depose. So we want to ask the white label partner. In our case, in your case as a white label partner, you'd be asking your client that's breached questions. And then also you're going to want to gather data. Now, the amount of questions, you have to look in your state. Typically, you can only get about 20 to 30 hours of oral deposition with a client. But I mean, that's a fair amount, and normally they'll limit it to about 6 hours a day, just depending upon your state regs. So you potentially could spend, a full week, maybe a week and a half, just talking to the person, asking questions for your discovery. Some people don't want to go through that, and they're like, well, you're right, I breached, I'd rather just pay. Some people will spend a week and a half with you just answering fucking questions ad nauseum. So here we have to restate their address and phone number. You have to state what you're expecting to get from it. And let's scroll on down. And then typically, in addition to the questioning of the respondent, then usually you'll ask for documentation. And again, this is really, really relevant. Let's cover it again. So if you're a white label partner and you have clients that have signed with you, one of the things that they've promised to do is to pay you a performance fee from any type of funding, from any source during the term of the agreement. So if they went out on their own and they opened a credit card, they owe you a performance fee off of that. For example, they went out and got a loan on their own. They owe you a performance fee for that. Well, how do you know? Because they're probably not going to voluntarily tell you that. So that's why you need to start gathering documents from the client. And so this could alter based upon the client circumstance. But for white label partners, for example, we're going to get business and personal bank statements. We're going to get documents, because in this case, Correlance didn't participate. She didn't enroll the number of clients she promised. So we need to understand why. So we get documents and records regarding that. We get an updated PFS. We need emails. Now you can get really elaborate on what's called e-discovery, but we'll save that for a different conversation. So we get communication from the client to third parties and so forth. So then it closes with a prayer. And I know that sounds kind of weird, but that's the way the legal system works. Essentially, it's the request. And so the primary request is to get a hearing. So normally the judge would receive the court clerk receives this, and then it goes to the judge, and then the matter gets set for hearing. And so then we will notify, always the other party has to be notified. If you're suing them, the way they're notified is different than if there's just a motion like this. Here we can actually notify them through email versus a sheriff coming and knocking on their door. But the goal is to get the hearing set up. And then once the hearing is set up, then the judge orders the written deposition. In other words, those 30, 40 hours of questions, and then the documentation. So from that, then you as the white label partner have a pretty good data set about the magnitude of the loss that you've incurred when you have a client that has not participated or not paid. Because often the deeper you dig, the more you realize that they actually owe you. So this is the process. So when we talk about being a white label partner, of course, our focus is to help clients access capital, but we have written agreements. You have a written agreement with your clients, and it states what you promise to do for them and what they promise to do for you. And if they don't do what they promise to do for you, they breached it. You want to try to resolve it amenably. And if not, then this is an example of the process to go through. For us, we're sometimes in that same unfortunate position. Not so often with clients, because most of our clients come through white label partners. I'd have to go back and look at the numbers. I would say, if I were to guess, and I didn't run a report before, we probably added, I don't know, probably just say 1,000 clients direct, access to capital clients direct in the month of December. But the majority of our business is not direct, it's through our white label partners. And so in some cases, we have white label partners that breach. So who has questions, comments, concerns on the topic matter? So the topic matter is, if you're a white label partner and you have clients that breach, you want to give them notice, try to resolve it. And if not, then it normally needs to be escalated. How you escalate it is up to you. But one strategy to escalate it is to do this, is to file a petition, which you could do or have someone else do for you before a suit is filed, using either federal or state rules of civil procedure. Okay, so I want to stop talking and listen more. So I'm interested in feedback that you all have. Was this helpful? Was this confusing? Does this help you better understand maybe what you need to be doing if you have clients? Because you should be doing an end of the year reconciliation just like we are. So for all of you that are white label partners, you should pause and you should look back at the clients that enrolled with you in 2022. And anyone that's not paid you as they should, you need to try to resolve that. Anyone that's not participated as they promised, you want to try to resolve that. And so it starts with just simply giving them notice, maybe sending them an invoice so they can hopefully resolve it. But if not, in some cases, it has to be escalated. And this is how we are now, as a policy, escalating for our contracts that have been breached. And you may want to do something similar. So Millie mentions about the difference between being a white label partner and an affiliate. And that's right. Some people are not cut out to be a white label partner. I think many of you are, because more sophisticated business owners, more experienced, thrive in this environment because you can generate a lot more money as a white label partner, but there's more involvement with it, right? An affiliate, super simple. Get a link and refer to. Yeah, so if anyone is an affiliate but wants to become a white label partner, let us know and we can upgrade you. Alternatively, if any of you are white label partners and you don't want to be, you want to be an affiliate, email us, let us know, and we can send you the opt-out form. That's not a problem. But I do respect two different roles. Pauline asked a good question about how far to go back. Well, there is what's called a statute of limitations, and it varies by state. And so I don't know about your state, Pauline, nor am I an attorney, so I can't give legal advice. But in Texas, the statute of limitations is 4 years. But that's not 4 years from when the agreement was signed. It's 4 years from the breach. So let's just say in Texas, we could fairly go back 5 years. So in your case, you'd have to look. You could Google what's the statute of limitations in your state. In some states, it's 15 years. But you could go back. Now, theoretically, you could go sue people even if it's beyond the statute of limitations, but that would be a defense. Like earlier, we talked about what are reasons that people could get out of paying you if they breach the agreement. They would need to come up with a good defense. A really good defense would be statute of limitations. Hey, this was 10 years ago. It's too late. But 80 to 90% of people that you sue won't even respond. Therefore, they won't even have a defense. Those are national numbers. So in your case, Pauline, you'd have to look at what the statute of limitations are in your state, and you could go back that far. And we're doing that. I mean, we're going back 3 and 4 years this week, and people are just freaking shocked. And it's like, yeah, I mean, you signed an agreement. You made promises. Just because you failed to fulfill them over 3 years doesn't mean that it's gone away. Jeanette says this is a negative way to close out the business year. Well, Jeanette, I think I see it opposite of that. If people owe you money, Jeanette, then I think you have the right as a business owner to ask them to do what they promised to do. And I think so often people, and I'm not talking about you, Jeanette, I respect you tremendously, but I think so often people go to the consumer mindset instead of the business owner mindset. Right? If you, Jeanette, you have an agreement with someone, you should do what you promised to do, but it's okay for you to expect them to do what they promised to do. And what we've talked about is not threatening. It's about Jeanette, you should reach out to your white label clients that have not done what they promised to do and give them notice. Not being mean, and this wouldn't be the first notice we're looking at here. You're just letting them know, hey, Joey or Susie, our records show you've not done what you promised to do. Let's resolve it. Right. So that's the ultimate opposite of being negative or threatening or intimidating. But Jeanette, you might be surprised, and maybe in your world, not so much, but it's not uncommon for people to not do what they promised to do. And so then you escalate it. And we're just showing non-threatening, non-intimidating, non-negative ways to resolve it, because sometimes people won't pay you as they promised to do. So I'm sorry, Jeanette, if you see it as negative, that's not the context that I'm trying to give at all. But if you run a business, Jeanette, and people contract with you and then you don't collect the money that's owed, that's probably inappropriate business practices. And some would argue, and again, I'm not stabbing at Jeanette, if you don't run your business properly, you may not be the right person to run that business. You may want to hire someone else to step in. And that's not unusual. Often founders of companies don't continue to be the CEOs. They have the idea, the insight, but then they step down, or maybe they become chairman of the board and they hire someone else to run the business properly. And you may be in that situation that you're not the right person to run your business. You should own it, but maybe you want to put someone else in that has more financial accountability. All right. Aziz has some great comments, and I want to repeat them all, but just very complimentary of this overview. So thank you, Aziz. All right, so with that being said, we're going to close out 2022. We will be back next Monday, normal time, normal place. We've had some really good trainings this week, and if you've missed those, I do strongly encourage you to go back and view those. All of you that are white label partners, we sent out a reminder this morning with links to the last few trainings. So thanks, everyone. Happy New Year, and we'll see you back on Monday. Bye-bye.